Damn StreamYard with these pop-ups. What are we going to do? What are we going to do? What are we going to do? Well, hello, friends, and welcome back to another episode of True Crime Metrix. Who is True Crime Metrix? Well, that's me. True Crime Metrix is a world-class gourmet chef. True Crime Metrix is a lover. True Crime Metrix has got a new video for you today, folks, from the very final Sarah Boone hearing before pre-trial. Pre-trial? Trial starts Monday. Jury selection starts Monday. It's a pretty good one. I guess a lot of people have seen it already, right? Where is it? Is this it? Yeah, it's a pretty good one. Sarah's going to be taking the stand. We get to see Detective Chelsey. Wow, she's had her hair done already for TV. The exchange between defense counsel Mr. Owens and lead prosecutor, now that Mr. Chicken Cacciatore's gone out the window. Back to rehab, Chicken. Mr. J and Mr. Owens kind of get a little heated, a little fiery before trial. Judge Kranick, or should we say Captain Kranick, has just flown in his very own Boeing 747. If you look out the courtroom window in this video, you will actually see the jumbo jet in the courthouse parking lot. He's got his very own plane. We can only hope that he doesn't pass on his kerosene bill as a business expense. But yeah, it's a pretty good one. And Sarah gets a little chance to warm up on the stand. I think that's why they put her on the stand here. She's only up on the stand for a few minutes to impeach the testimony of Detective Chelsey about how she didn't complete the Miranda warning. And actually, all the way through, it looks as though the judge is not having any of this stuff from Mr. Owens about, hey, he's like, no, there's no case law. There's no case law. That's not the law. But the argument that Mr. Owens puts to the judge towards the end of this video is pretty damn convincing. I left thinking, yeah, that was illegal. Absolutely. But the judge didn't rule on it. Courthouse is closed tomorrow, but Judge Kranick, Captain Kranick, will be in the courthouse working, because it's the final day. So he's going to send out a written ruling at some point tomorrow. So look forward to that. Kind of a little bit of anticipation pre-trial. And what else? Well, I guess we're just going to play the video and see how we go, guys. Hello, everybody in the chat. Sarah Boone's trying to grow that hair back. Or is she? Or has she had it cut again? What is, if you've got a neck like that, cover it up with hair, okay? What a horrible neck. It looks like the thumb of a giant. Her head is a thumb wearing a wig. Awful. Awful. Yeah, hit those likes already, guys. Right on the way in. Get them going. Get them going. Yeah, there is no sound yet, but I love just watching Sarah and Mr. Owens lay out a load of paperwork like they're going to win the case. How many water bottles does this guy need? That's not normal. They're very small, though, aren't they? So they could save the plastic and just get one big bottle. We could all drink from the same bucket. We'll just pass it around the courtroom. Big bucket of water, big bucket of ice. Look at Mr. Owens. Yeah, lean in and talk to your client. I've worked it out with Mr. Owens, by the way. I think he's just maybe he's like a divorce attorney, and he's about to retire, obviously. So he's like, hey, I could sit here for the next 2 years and handle a load of miserable couples that come into my office, or I could take a chance and do one more big case. The case that I never got to do because I went into family law. She has no one. I'm sure it's easy to find out about his background, and I wish I had the time for that. I'd be all over his background. All over him like a rash. Dermatitis on Mr. Owens. Look, Sarah Boone forgets to stand up for Captain Cranick. Oh, everyone's standing up? But I'm exceptional. I have a giant thumb neck. Here he is, getting in the cockpit, putting on those big earphones. You know they get special in-flight meals, don't you? They don't eat the rest of the shit. They have what they want. Okay, let's get some audio going. Look, he's at the control panel. Yeah. Everything seems to be okay with the left wing. This is mission control.
Clark, I'm ready when you are.
David Ketchner on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
What's his first name? Changs Owens.
David Ketchner on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Changs Owens, okay.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian, and clothing without...
Yeah, but Carrie Brooke, you have earned extended spam chat privileges for sure. Your comments are hilarious most of the time.
Restraints for trial. Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order.
Whatever it is he's subpoenaed, whatever that nothing motion that this nobody lawyer has subpoenaed, I'm not objecting to the authenticity of his piece of shit, worthless, useless motion that I don't even need to say because it's going to be ruled against. But
711 I don't see any need to belabor the custodian of records sitting around. Was there something else? Did you direct the Miranda card?
Yeah, if you look
Fine.
in the very back. In the very back.
Okay.
You see the Miranda card, the last page, and the next one.
Mr. Owens is a real paper person, isn't it? Not a laptop in sight.
Last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell what you can?
Yes.
Good one, Dan. Dan will give a free tattoo of 10-10-7-7 if they are ever in Ireland for free. Doubt he'll get any takers. You thought wrong, Dan, because we're all coming to Dublin. Or Galway, or wherever you are, man. Yeah, Leslie, I don't know if Sarah Boone's hair gets shorter or her neck gets bigger. It's horrible. It's ugh.
I also have reviewed the 2 hour and 6 minute.
By the way, disclaimer, guys, audio is all over the place with this video, so I'll do my best to manage that. But if anything gets really annoying, too loud, too quiet, whatever, let me know. I'll see what I can do.
Investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court for the clerk to mark A for identification is a DVD, courtesy copy, body worn camera.
Jill Jane says she doesn't think that Sarah looks like a thumb, but another appendage form. What, like a penis? Just a giant penis in prison scrubs. Just a giant penis with eyes and arms and a face and a wig, a bad wig on a penis.
And I have reviewed all of those in advance of today's hearing.
That's mighty generous of you, Dan. Listen, I want a full-size Georgia Cappleman on my back, taking up the whole back.
Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1. Good afternoon, ma'am. Could you?
Oh, hang on. Just before we get to Detective Chelsey, did everyone see Sarah Paulson with long hair? How do we share this tab? Share this tab. Look at her. I think we can agree that there was already something very wrong. Edgewater. There we go. Back to Detective Chelsey. Now, Chelsea's turned up the style a bit, huh? Got her hair done. Got her hair done for the cameras. This is probably the first time that Sarah and Chelsey have seen each other since that fateful day on February 25th.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsey Castle. Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes,
And each of the third weeks you will be on call?
yes,
And then through some other random distribution, it's determined who of the 4 will be the lead?
correct.
And it was your turn to investigate the death of Jorge Torres?
Yes,
And you were notified of this on February 24th of 2020 in the afternoon?
yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Owens, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
Here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there.
Jill Jane, Sarah wants the video interrogation thrown out. What else does she want thrown out? I just watched this. Was that it? I think there's another thing. The main thing is she wants the video interrogation thrown out because Detective Chelsey here didn't complete the Miranda warning.
So once I spoke,
Which sounds like a pretty spurious argument in and of itself, especially when we look at the case law, which doesn't say anything about question number 9. Question number 9 is the bit at the end of the Miranda warning where it says, having these rights in mind, do you now wish to talk to me now? She didn't say that, but it's not a requirement. It's part of their policy, but it's not a requirement. So the argument does seem a little spurious, and the judge gets pretty frustrated saying, stop trying to get this removed. It's not. But then Mr. Owens really starts earning his money that he's not getting any. But, he comes up with a pretty good argument. I was pretty much convinced, and the judge hasn't ruled on it yet. Written, what do you call it? Shit, my mind's gone blank. It's almost 3 a.m. What do you call it? Written ruling tomorrow.
spoke with deputies. I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond,
We need to do a special edit for Detective Chelsey and get all of the ahs and just put them all together, because I think it would be a 3-minute video. A little bit embarrassing, Chelsey.
to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this?
Business casual, is that what we're calling it? Have you not seen the video, man? That guy was wearing a shirt that you could wear to the very bottom of the Mariana Trench and not get wet, you know? Everyone it was his birthday in the sheriff's department that day, and all of his colleagues took his shirt and covered it in molten plastic as a prank, and then they made him wear it. Business casual, yeah. Detective Scott was in his normal business casual, his normal business plastic casual.
This initial interaction with Miss Boone?
Not long. Maybe a couple minutes, 2 or 3 minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it. Didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive? At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Not go back in her house.
Prior to that, had she been detained and requested not to leave the scene?
Right. One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there?
Carrie, this is Mr. J speaking. They won't let Cacciatore out. I don't even know why he's sitting there. I don't think we're going to hear from him much in the trial. I mean,
You had
Mr. J is clearly a lot better.
requested that Miss Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We're able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right.
Yeah. They were going to run over to Sarah's ex-husband's house and deliver the phone and interview her without the advantage of having it captured on video. They were going to do that for sure, but they didn't want to arrest Sarah in front of the boy. That was the real reason, folks.
Right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen went down and got her.
All right, so you're describing two separate entrances.
Hey, how are you? I'd forgotten all about that, Monica. I need to write that on my wall. That's the best one. Hey, how are you? I'm gonna do an edit of that soon. Maybe tomorrow. Just take the time, go through all of that friggin' phone call shit again, and grab every single one of them. Hey, how are you?
Is that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card?
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Yes, I've definitely viewed the interrogation video. In fact, I saw a wonderful analysis of the whole thing on True Crime Metrix. In fact, 3 versions of it, I think. Is that how many we've done? Talk about milking the cow.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or?
He wasn't a suspect or a person of interest in the murder. But the night previous, a whole shipment truck container went missing from the Mountain Dew factory. So we had a lead on him for that.
Person of interest?
At some point?
50,000 gallons of Baja Blast went missing. And we need to speak with Brian Boone.
Yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
Mute. Thanks so much for the super chat, Victoria Girl. And yeah, good to be back. Good to be back. We're so back. We're out of this Adelson reaction. Got to get back on it. We got a weekend, and then we're on to jury selection. Sarah Boone. We're starting Sarah Boone's trial. Then we've got Donna Adelson's case management hearing on the 15th. That should blow some shit up, huh? God, just when the drama was dying out. Let's go to war.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for a password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the
God damn this mute microphone thing. This is what happens when you have to eat rice cakes at 3 a.m. Yeah, so yeah, we are going to be starting to review Russell Williams, re-reviewing for the 100th time tomorrow. You know, there's a lot to be said. There's a lot of tangible things to be said about that one. It's not just giggles with Russell Williams. We need to actually come up with some good things to say because there's so much. It's the best interrogation in the public domain. And there's a lot of good things to cover. Technical things, you know. We might spend a bit of after this Sarah Boone trial and whatever happens with Donna. I think we're going to be spending a bit of time in Canada. You know, we've got Jennifer Pan. We've got that freak from Woodstock, Ontario. What was his name? Michael Rafferty. Ugh. But we also get to see Jim Smith in his interrogation, playing a bit of a different role. Not so soft with Michael Rafferty, and it's not hard to see why, right? What else have we got up there? There's a bunch. Oh, there was that kid who killed his own dad. He took a load of mushrooms and then killed his own dad. And they interviewed him when he was still tripping. Man, try and explain that one in the morning.
the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by.
Okay, no more rice crackers. Jesus. The 2-minute video of George in the suitcase, doesn't that sound like one of those never made it, nothing late 80s Disney movies? George in the Suitcase. Starring Steve Martin as George.
And I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those two videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it?
This whole hearing is a bit of a warm-up for everybody, right? Mr. J is hot on the objections. You know, it's like he's just come out of training and he's ready for the big race, you know?
She claimed that I said.
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
It's interesting she should say that because she just said a moment ago that she didn't remember if she interviewed Brian inside the car or standing on the sidewalk. Now she's saying she would never interview. Okay, maybe she's just talking about Sarah, but is there a distinction? Brian's at the scene. He was in the house. He could be just as much as a person of interest as Sarah.
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay.
She's got some sass on her. It doesn't take, much to get her mad, does it? Impatient.
Or why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
All right, lady. What's with the attitude?
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. You don't.
Riding shotgun. Michael Rafferty did possibly the worst crime I've ever heard of. He makes Chris Watts look like an altar boy. He makes Brian Koberger look like a saint. Michael Rafferty, I can't even repeat it. Can't even repeat it. But we'll have to. I don't. Maybe I'm going to skip it. It's just such a horrific crime. Check it out. It happened in Woodstock, Ontario. But the interrogation's great. But the story of what he did, brutal.
Don't recall whether or not you said this is routine protocol to come into the car and talk to me.
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you You didn't ask her the last question, number 9.
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what
What's RBF, Leslie?
the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
Ooh, big allegation there. It was an attempt, not a mistake. A specific, designed, orchestrated attempt to coerce Sarah Boone illegally into talking.
On February 24th or on February 25th?
Them's fighting words, right?
February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States, and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters,
Look at
is
that. Talk about attitude there. Big turn. Take my glasses off. I mean, that's what you do when you're expecting to be punched or you're going in for a fight, right? Take the glasses off. See that again. He says, I would ask that we call people by their surnames, not their first names.
is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that
Because he's from Pepsi Cola, right? He's all the way from Pepsi Cola. And this is a local administrative order to call people by their their surnames.
Defendant was read
But wait and see what happens next. So funny.
what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say?
What a burn is that, man? And you referring about surname? What do you mean by that? It means last name, family name, like Mr. someone.
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is.
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read from. You can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference.
Yeah, our whole system of justice agrees on this Miranda warning to read out a set list of questions. But in my office, we have all different ones. Yeah, the last card I had just had question 4, 6, and 9. And then I got one that was question 1, 3, 6, 8. It's just random, which saves on printer ink.
Policy, yes, it is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion?
I've become more aware, yes, that there is that card.
Maybe she just keeps the card in her wallet, and it's the 9th question is covered up by the black leather frame in the purse or something.
Have you gone and gotten the updated card?
Objection, relevance.
Sustained.
Detective Scott's probably running back to the sheriff's department now with a pair of kitchen scissors, cutting all the number 9 question off the bottom of the card. See? Only 8 questions.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure where she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
Yes, it was happening.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection.
Overruled.
I tried, but he was on a scuba diving mission wearing only his shirt.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained.
Yeah, Esmeralda, this guy is really trying to get this this tape thrown out. And the state calls it. It's so that they can have a different defense. And if the evidence that's on the tape can't be shown to the jury, the state can't impeach that evidence as false. It would really turn things upside down. It's quite an intense moment as we're waiting for Captain Kranick to get out of the 747 and present the written motion. Ruling, sorry.
You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I could probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video?
I don't believe she's got a lot of confidence either, Neverly. All this, that is not confidence. She becomes aware of it in a moment and stops doing it, but I bet that takes some effort. She does have this attitude. Like, I thought it might have just been with Sarah, but it seems like it's just her thing, this attitude. Imagine going to dinner with this lady. This needs salt. This needs salt. I ordered medium rare. What is this? This is well done.
Video, the two videos from her phone
I don't want butter in the mashed potatoes.
the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
She was not,
Excuse me?
she was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
Objection, relevance. As to what probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the video, the two videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection, relevance.
Overruled.
Thanks so much, Carrie, for the super coffees. That is really appreciated, Carrie. And just a reminder, everybody, the best place, the very, very best place this month to support the channel, to support Metrix, is buymeacoffee.com. Because we had to take days off on YouTube after that frickin' Donna Adelson depression set in. But now we're back. Now we're back and we're not stopping. We're not stopping. But YouTube's going to take a hit this month, man. So everybody go over to buymeacoffee.com if you want to support the channel, or leave a like on the video, subscribe to the channel.
The videos, I'm sorry, repeat your question one more time.
And thanks so much, Carrie. Again, you are really appreciated. That's very kind of you.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, relevance.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a
Yeah, Mr. J is gunslinging with these objections, and he's got like good grounds every time. He's really quick. He's just on his game. It's going to be, and you know, Mr. Owens is pretty high energy as well. This is what I'm saying. It's a good warm up. It's like they're sparring. They're just, you know, jabs. Get a few jabs going. Stoke that fire. Ready for next week. Can you imagine? They start to tell us a little bit in this hearing about some of the additional evidence that we can expect to be shown in the trial that no one's seen yet. No one in the public eye. We've been following this case since 2020, 4.5 years or more. And it's all going to be happening this week, this coming week.
chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection, best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013.
How long have you been a homicide detective?
Over 6 years.
Okay. Have you ever been trained or told to ask or not to ask?
Imagine if Detective Chelsey's kid married Sarah Boone's kid. They're only 10 years apart. They both live in Winter Park. It could happen.
Any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us,
So what would that make Detective Chelsey and Sarah? Would that be like sisters-in-law? No. They'd both be mothers-in-law.
if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room?
I must have missed the green. Dan, who's wearing green here?
So you would have had that on your person?
Yeah, and you just know that she does look different, right? Lego person, but you just know she doesn't have her hair like that every day. She knows she's going to be on TV. Again, chicken cacciatore's in the corner going, object to relevance. Object to relevance. Mr. J's like, I know, okay? Take another Xanax.
You may.
Maybe Esmeralda. Are you Big Sky 123? Let me see. Oh no, Ezzy. Ezzy 123. Yeah. Thank you so much, Ezzy. But it doesn't Esmeralda. It doesn't come up with your name. It just says someone. But then I can see your email ID. Yeah, if that's you, Ezzy, Esmeralda, thank you so much. That's really appreciated. And Glad to see you. Good to see you. It's good to be back, guys. It's good to be. It's been too long. It's been too long, and we're rolling out every day now. Every day, we can't stop this train.
If you would, see if you recognize that document.
Yes, this is our waivers and affidavits.
And is that a filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And is that form filled out as it relates to city?
We're talking about just this top, right? Okay, I'm sorry. Does it what?
Is that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature or what?
Yes.
And is that the consent for the form?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
You would agree that there's not in questions?
Yes.
Somebody would like to offer this?
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement.
You see, this is interesting because they're not disputing the fact that she was in custody on February 25th when she gave a statement to detectives. But in that interrogation room, she hadn't been arrested yet. So why is it assumed that she is in custody?
Requirement for this question 9 under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Absolutely, Carrie. Mr. J is on fire here. He's really quick. He's efficient and clear and effective. Thank God. I was getting really worried with Cacciatore,
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card.
Honest mistake now. I thought you said it was an orchestrated, planned, deceitful attempt to withhold her of rights. And what did he say at the beginning? Now it's an honest mistake.
But still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
I mean, the way I understand it is that the reason we refer to case law, and it's stuff from 1983, 1881, you know, all these dates through history, is because as and when the legal system comes across situations that calls for redefinition, it goes into the legislature, and then we can refer back to it when we're in a similar set of circumstances, and we need to say, well, what did those guys decide at that point in that similar situation, in that similar case law, right? So why can't you just say, well, make this a case law? State versus Boone. State v. Boone, case law, 2024. If question number 9 isn't read off the Miranda warning card because Detective Scott has gone around and cut it off with his kitchen scissors, then the defendant shall be released. We need an actual lawyer. Uh-oh, what's going on now? Are we paused or? Oh, what is this?
you would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yeah, we only need another 10 likes, guys, for our classic True Crime Metrix 100% ranking. Check it out. Hit the like. Another 10. That's easy to do. Come on.
Yes, I had more evidence.
That was without the autopsy.
Yeah, Soap is playing a trombone tonight, folks. Soap bone.
Was without
She's like, did somebody say bone?
the 2 videos from her phone in the squad car.
Yeah, I did at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Well, if she wanted to talk to you, maybe you should have gone for lunch and complained about the saltless, flavorless, butterless mashed potatoes. And then, you know, who would want to talk to you?
That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. Maybe more witnesses.
Hello, Anne-Marie Marion. Yeah, Anne-Marie says that she's resisted watching this case until tonight. Not much else to follow. Why are they giving her so many damn chances? Is it finally going to trial? Is this white-haired fool her newest lawyer? Yeah. Mr. Owens, out of Pepsi Cola, is her latest number 10, lucky number 10. And yeah, it's definitely going to trial. This is the final pretrial hearing, and the courthouse is closed tomorrow, and they'll be in the courthouse on Monday morning, back at the courthouse, 9 o'clock sharp for beginning jury selection. But the main point that's being argued in this hearing is whether or not the judge is going to allow the 2-hour interrogation video of Sarah Boone to be what do you call it, withdrawn, taken out. They can't use it. What is the word for that? I forget. And he's not decided yet. He's going to issue a written ruling tomorrow. So it's kind of suspenseful because that's a very juicy bit of evidence for the state. And if it's not permitted to be submittable as evidence, it will allow a very big shift in the type of defense that Sarah can put on and present to the jury without fear of that video being able to impeach that new fantasy defense, right? So if they successfully get it out, and it hasn't been ruled upon, folks, if it successfully comes out, and it's a big if, it really would be a game changer for Sarah's case. But I guess that won't happen.
Just that one.
What is it that's been marked as Defense Exhibit B?
And thanks so much also for the coffee, C. Johnston. Thank you very much, C. Johnston. It's most appreciated.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same argument.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
See that Papa Owens hug of encouragement, nice tap on the shoulder. You can do it. Get up there and perform. Friar Tuck. Does anyone remember Friar Tuck? If you shaved her head just in the middle at the top, and left the rest of the hair in place, put an old monk sackcloth robe on her, it would be Friar Tuck, you know, from Robin Hood.
Do you know what page specifically those policies are on?
Page 14 of 22. I'll give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be received into evidence. Over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her. Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here?
So this is her big practice, right? You know, Mr. Owens has been prepping her for this for several days, I would imagine, and wants to see how well she responds to, scripted answers. She has no demeanor. You can tell she's only remembering, what did we say in preparation? Okay. And Mr. Owens just wants to see how it looks on the stand. He's like a great artist, a few strokes of the brush and he'll paint her out of jail.
Here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase.
What a sentence, huh? Let me take you back to the morning of finding George Torres in the suitcase. Hey, I know. Why don't we go just 12 hours back further to the moment that she put him in there? And then found him in the morning. It was hide and seek. She hid him and then she found him.
You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy.
Hazy, yeah, I'll say. Like 15 margarita hazy?
Didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son.
This is Sarah's first time acting, clearly, and it shows. It was confusing. I'd even go so far as to call it hazy. I was worried about my dogs and my son. I'm a loving mother.
I was in shock.
This is something bad actors do all the time, this little rising intonation thing where they only know how to act one kind of expression, right? So they repeat it all the time. I was in shock. I was hazy. I was worried about my dogs. Let's see it all again.
Interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that
Yeah, I did call 911, but first I called 916, and then that was the wrong number, so I tried 914. And I just, but on about the fifth attempt, I got through. I had to go through all the numbers.
Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about.
Sarah, you haven't sobered up. At the point of arrest, you had not sobered up for at least 9 years straight. You went from being hungover every day to getting right and then drunk again and then paralytic, right? So it goes like this every day: hungover, getting right, drunk, paralytic, and then there's a fifth one that no one can ever remember the name of, and then back to hungover again. It's called a cycle.
I'm just getting some preliminary information.
But we're
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained, and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by those to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
I was terrified of his family. And also, Brian had some really, I'd given him a bottle of dark rum for his last birthday, and he doesn't drink dark rum. So I went to Brian's house.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Objection. Irrelevant what your statement is.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
So I didn't call for a yes or no. She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No,
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
yes,
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copsell was pregnant and not feeling well?
correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt.
What was he wearing? I don't know how to describe it. I thought it was a prank at first. I thought I'd won a prize.
Along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No,
Okay. So directly off the elevator and walked into the interrogation room.
correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes,
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
yes,
You recall that happening.
yes,
Did that refresh your memory watching the video?
yes,
Do you recall her saying that she had received the autopsy?
yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
You know, I can't wait for when he sums up the totality of the circumstances, because it does seem really like each little thing on its own isn't enough, but the totality of the circumstances, he does a good job at making it seem pretty coercive.
She also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes,
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
in every way,
Were you trying to cooperate?
in every way,
Were you polite with them?
very,
And when she said that, we just have to do it, you said, just like we did yesterday.
yes,
And then you said, normal protocol.
yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes,
And she, Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
Well, it wasn't caught on camera, Sarah. You know, and I've said it before that I think Sarah says normal protocol all the time to the property manager, to the cops that come out to their house 4 times a week. You know, normal protocol. You arrest us and take us to jail. Normal protocol. Property manager's like, yeah, one more instant and we're out of the complex. Protocol. I don't think Chelsey said it. I think Sarah said it, because you see Sarah say it on the first body cam interview at the scene, but you don't see Chelsey say it.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does
Good point.
her subjective perception matter?
Well,
apparently not. But they keep saying she was in custody. She wasn't in custody. She wasn't in custody until she left the room. And if they'd have put her in cuffs at the beginning, she wouldn't have said anything. They just don't want to say, listen, Mr. Owens just doesn't want to say, Captain Kranick, my client was so stupid that she thought she could actually talk her way out of this.
under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is.
One of them was wearing a firearm. All right. Okay. But well, he didn't like take it out and put it to her head and say, if you don't talk, I'm going to blow you away. That'd be coercive.
That she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objections overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Mimosas. Listen, buddy. This woman only drinks the boxes of wine that are just labeled red. There's no mimosas around here, buddy. And the only reason she didn't drink in the morning is because there wasn't anything left in the house.
You consumed no alcohol in your home that morning, correct?
Again, regretfully.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
That's a damn good question. Can anyone bet whether it would be better for Sarah to say yes to that question or no to that question? Did the effect of the alcohol that you were under the influence of affect your memory when you were talking to Detective Copesel? What would be the better answer? You see Sarah's, I think they zoom in on her in a second, and you see her tiny alcoholic mind just going, shit, give me a minute. I got to think this through. What would be better for me to say?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands.
I don't.
Okay.
It's been asked 3 to
Maybe Mr. Owens needs to get a selection of different colored folders and assign meaning to each color and hold one of them up. The red folder is no, and the green folder is yes.
different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is.
I think in the prison, if they can't make any toilet wine, they might be able to still squeeze some alcohol out of Sarah's cheeks. Just the volume of those cheeks is probably a whole quart of vodka on each side of her face.
Biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now if he's going to question her about what was said during that evaluation. And he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Oh, here we go. Yeah, he's gonna do a summary now. And it's pretty good. Even the judge thinks it's pretty good.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of "we have to read you the rights" was made before "we have to talk to you." So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Copsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Copsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Jim, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, I just want clarification, but, you know, she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent.
I thought they were going to do the stun cup.
I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature.
Flee to the nearest bar. There's a pool hall down the road, Sarah, 3 blocks up, 2 over.
She has a fundamental right to a fair trial. She has the fundamental right to the presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart.
Yeah, but even without the leg restraints, all she has to do is talk.
And it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny as she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative. And she understands the importance of behaving. And I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe so.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail. and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
The other problem is what's it gonna do to help? Why don't we go and get a pig, put some lipstick on it, and put him on the stand? Polishing a turd.
Lines.
Well, I'm gonna have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But
Well, a beautician consultant. We'll need a team. We'll need a full team of beautician consultants. If we
females,
get close,
and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Miss Boone?
Carrie, he's not ruled on everything yet. You've still got to hear from him about the suppressing the video evidence. That's the word I was looking for. Suppress. But no makeup, no hairstyling, and she can have civilian clothes, but they have to be delivered to the jail.
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning.
That'd be great, wouldn't it? Sarah's like, the jury are coming in. She's only got half her face done. One eye mascara, one eye blue eyeshadow.
So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints, but the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes. Yes. So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of jail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate. have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is
Through her phone.
immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument.
Coaching him on how to drop charges on her? Is that what he just said? Yeah, I'm a battered spouse. But listen, you need to go and talk to the cops and drop the charges, and you need to say it like this.
Charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is
Battered spouse syndrome, everybody.
going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, Paul's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on it. So,
Okay. Go ahead. I'm sorry.
those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the
Colloquy. How many colloquies can this guy quell?
potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
And that's it, folks. Well, I guess we'll see them Monday morning at 9 a.m. There's going to be a written ruling tomorrow on the suppression of the video interview. I don't think that'll get passed. What a game changer it would be if it did, though. Anyway, tomorrow, guys, I think we'll be catching back up. I've been going over the Ezra McCandless case more and more today. Man, there's a lot to get through. There's a lot of complicated details to get through, but it's very good. And the Jason, what's his name? Jason Mengel. Jason Mengel testimony is so good. So both direct and cross. It's just, what the hell is going on here? So I think we're going to be back with that tomorrow. And then, hey, Monday, we're back in Orange County, Florida. Thanks so much to the supporters. If anyone has wants to let us know cases to cover, you can send us an email at truecrimemetrics@gmail.com. Yeah, we get a lot of emails on there, and we do look at them all. And we're making lists, but it's a good place if you want to put some cases to cover on there. What else? Thanks to our supporters. Buymeacoffee.com is definitely the place to support the channel this month, guys. It's so much easier for us. We can come back to YouTube support later, next month, but this month it's all about the coffees. So links in the description for buymeacoffee.com, Patreon, Discord, and merchandise, and all that good stuff. Social networks as well. We got well over 100% likes quality on the viewers tonight, guys. That's fantastic. Well done, everybody. What do we get? What did we get? What did we get? Smashed it. Smashed it into pieces. Okay. I think we're done. It's 5:14 a.m. I'm going to get 3 hours sleep, and then it's back to work. Back to work. Busy day, busy day, busy day. Good night, all. Good night, all. We need a new sign-off as well. We have to come away from the Edelsons for the time being. But for now, until we get a new one, be kind to each other. don't be an Adelson, and have a safe drive home. True Crime Metrix out.